All right, guys, as promised, better late than never. I'm going to go over some of all of the cases that you had on your chart. We're going to cover the constitutional issues of the case, and I'm going to go over the majority and, in some cases, the dissenting opinions. Obviously, some of the cases were unanimously decided, so that means there were no dissenting opinions. So those of you who are filling out your chart, finishing that up, if there's no dissenting opinion, you can leave that box blank. All right, so let's begin. The first case, obviously, and the first two I did for you, but I'll go over them quickly. Very important. Marbury versus Madison was the case that established the Supreme Court's power of judicial review. So make sure you know that. Very important. Without this case, the other cases wouldn't be able to be decided by the Supreme Court because they wouldn't have that power. So this is an important case because they did establish that power of judicial review. Once again, a unanimous decision, no dissenting opinion. McCulloch versus Maryland, another early court decision in American history. The decisions were issued by John Marshall, who of course was a Federalist and wanted to see the power of the federal government expanded. So this case is one of those cases that expands the power of the federal government over the states. It had to do with the National Bank, which had been created at that time, and whether or not this National Bank was constitutional. Since it's not in the Constitution, there was the argument that it shouldn't exist. But the courts decided that it could exist based on the necessary and proper clause, which gave Congress the power to, the implied power to create a national bank to help regulate the economy. And then a secondary issue had to do with states' rights to tax that bank. Since it sat within the state's borders, could it be taxed? And the court said no, because of the supremacy clause. Because it was a federal institution, the states had no power over it. Therefore, they could not tax it. So that goes back to federalism and the idea of supremacy of the national government. All right. The United States versus Lopez. This was the case about restricting gun use or gun carrying in school zones. And Congress used the Commerce Clause to try and exercise that authority to prevent guns from being carried into schools. The majority decision here, 5-4, basically placed limits on the Commerce Clause. The court did not see the connection between the Commerce Clause and trying to regulate carrying guns in schools. So they struck that law down. In the dissent, the dissenting justices argued that Congress had an interest, a rational basis for wanting to prevent gun violence, and the Commerce Clause gave them enough authority because there is a potential negative impact on economic activity with the carrying of guns in schools. So they did see an interest there, a connection, but they lost. The majority decision stood or stands, and that's the one we go by. So any of these cases where we're looking at a dissenting opinion, just understand that the law or the majority decision has the force of law. The dissenting opinion is just important to see the other side of the argument. So if you want to focus on something, make sure you focus on the majority opinion. All right, the next couple of cases have to do with drawing congressional districts, which we talked about before. Baker versus Carr, the idea of whether or not even drawing these districts was a federal issue. Could federal courts even look at congressional redistricting or districting and make any sort of decision, or was it something that the states had sole control over? So with Baker versus Carr, this established the precedent that yes, the federal courts could, in fact, look at how congressional districts were drawn to make sure that no one's rights uh, were being violated within the drawing of those districts. And especially if districts are drawn based on race, that goes to the heart of the 14th Amendment, the idea of equal protection. Therefore, it did give the federal courts the authority to look at how those districts were drawn. The dissenters disagreed. They said even if districts were drawn based on race, that didn't account. That wasn't the same as taking away someone's right to vote. Therefore, it was not an issue that could be looked at the federal level and had to be left to the states. Shaw versus Reno, 1993, a North Carolina case, looked at a specific district. District 12 at that time was drawn to pack African American voters into a district. A white voter challenged this, claiming that because the district was drawn solely on the issue of race, that it was unconstitutional. And the court did agree, even though they said that you could take race into account when drawing districts. It should not be the only reason you look at a voter's race when deciding which voters should go in which districts. The dissenters disagreed with that and said that the only time race could not be used was that if it benefited the majority or white voters. So in this case, looking at race benefited African American voters, even though I think you could argue that in a way it might have disadvantaged them, or it's a form of segregation, really, placing African American voters into their own district. Remember, we watched that video. That was a form of bleaching. It was called bleaching the other districts, taking the black voters out of those districts. So there's different ways you could look at that issue, but focusing back on the majority said that in this case it did violate the Constitution because they were only looking at race when they drew this district. All right, the next case is a religious-based case, First Amendment case, dealing with the Establishment Clause. So in this case, it had to do with whether or not in public schools they could have a prayer time, and the school officials would lead the students in voluntary prayer. Students did not have to participate if they didn't want to. So the idea is that constitutional? Well, majority, 6-1, so heavy majority here, agreed that in public schools, having this voluntary prayer time officially was violating the Establishment Clause. There was too much connection between the school, which is a part of the government, and religion. So they saw it as a form of endorsing religion. There was one lone dissenter, and he argued that because it was voluntary, then no one was being forced to recognize a religion. And in fact, he argued that you were denying the other students their right to practice religion, even in a public school setting. All right, another religious-based case here, Wisconsin versus Yoder. Here, this had to do with the state's requirement that students go to public school or go to school until they are 16, and whether or not that violated, in this case, the Amish belief that public schools or schooling in general outside of the home corrupted their children's religious beliefs, and it went against their religion to keep them in school that long, because at that time they wanted them to be homeschooled starting after 8th grade. So they didn't want them to go to high school because they felt it was against their religious beliefs to send them into those environments. And the court agreed unanimously, said that the Amish community's First Amendment rights and their beliefs about not wanting their children to be put in those settings, that was a legitimate enough religious belief. It was sincere, and that the law, of course, burdened them by trying to make them send their kids to school at that age. So they struck down that law in this case and said that the Amish had a right to pull their kids out and homeschool them after 8th grade, and that the law could not burden them, could not force them to send their students to school. Now, there was something called a dissent in part. He agreed with the ruling, but he had a different opinion about why. He disagreed that it should be up to the parents. He felt that it was the children's religious beliefs that should be looked at, but in this particular case, the children wanted to go home, wanted to not go to public school. So this judge would have looked at whether or not the kid wanted to go to school or whether they wanted to be homeschooled, not dealing with what the parents wanted. All right, then we get to freedom of speech issues, Schenck versus the United States, a very famous case. You might remember it from civics. And basically during World War I, Schenck protested the war, and he actually encouraged, passed out literature telling men that they should not register for the draft and not answer the call if they were called to go and serve. So he was arrested for that under the Espionage Act of 1917, and the court agreed unanimously once again that in this case the law was justified and that his speech was considered a clear and present danger. And this is one of the last things we talked about in class before the virus, was that sometimes speech can be limited. If your speech is dangerous, that speech can be limited. So this case established that idea that, especially in times of war, speech can be regulated and limited. All right, Tinker versus Des Moines, I.S.D. Independent School District. So another war was going on here, the Vietnam War. Some students, you see there at the bottom, wanted to wear these black armbands to school as a way of silently protesting the Vietnam War while they were at school. They were eventually suspended for refusing to take those armbands off. And in this case, the majority opinion here, the Supreme Court ruled that the armbands were symbolic speech, and that because it was a silent protest, it was not interfering with the school day directly, and that the school had no right to limit that form of symbolic, nonviolent speech at school. The dissenters argued that, in fact, there was some disturbance at school because the students protesting would be so fixated on their protest that they wouldn't be able to focus, concentrate on what they were doing at school. So in a way, there was this distraction being caused at school by their speech, their protest. All right, we move on to freedom of the press here. Once again, during Vietnam, President Nixon wanted to prevent the publication of what he deemed it was classified information by the New York Times. So they wanted, so they knew what the newspaper was about to print, and they wanted to stop them from printing it. So that's the issue here. Could you prevent the press from publishing a report that was considered to be classified? We call that prior restraint. And the Supreme Court decided that prior restraint could only occur if the information being published would bring some sort of harm to the United States. And in this case, even though it's classified, they didn't feel that there would be any harm brought to the United States with the publishing of it. So the idea of prior restraint is really looked down upon by the courts. We don't like to prevent the press from running a story, even though after that story is published, there can be some penalties like lawsuits and things if the information was deemed to be false, or in this case, the government possibly could punish someone for leaking that classified information, but you couldn't punish the press for publishing it. The dissenters wanted to side with the president. They felt that the First Amendment shouldn't degrade the president's authority as commander-in-chief to determine what was a matter of national security. So the dissenters here wanted to side with the president and respect the executive branch in this case for determining what should and shouldn't be published, particularly about a war that was going on. All right, McDonald versus Chicago. This is a Second Amendment case. It's also one of the cases that, or the case that you need to be familiar with when it comes to selective incorporation. So that's a term that you need to understand how the Bill of Rights, which were originally created and applied only to the federal government, how over time the Supreme Court has selectively chosen certain amendments out of the Bill of Rights and applied them to the states. Okay, so that's important. So here this has to do with the Second Amendment. So just in 2010 has the Supreme Court gotten around to applying the Second Amendment to the states. And in this case, the idea was how far could states go in restricting private gun ownership, or what kind of burdens could they place on gun owners at the state level. So the Supreme Court said that the Second Amendment does in fact apply to the states, and that state governments are limited in how far they can go in regulating gun ownership from a state level perspective. So they did fully incorporate the Second Amendment to apply to the states. There were some dissenters that said states should not be prevented. The Second Amendment allows for regulations, and the Second Amendment should only apply to the national government in terms of what they could restrict. And so in this case, the dissenters wanted to protect the states and allow states to restrict gun use if they felt that it was necessary. But the majority said no. The Second Amendment prevents state governments as well as the national government from doing that. All right. Gideon versus Wainwright. So here, once again, the word incorporation, we're selectively taking the Sixth Amendment, the right to counsel, which at a federal level, the federal courts did provide lawyers in capital cases for defendants that couldn't secure their own lawyers. So in this case, the question went, did state courts have to provide a lawyer to a felony defendant, or did that defendant, was the burden on them to get their own lawyer? So in this case, Gideon, who was the defendant, he was too poor to get his own lawyer. He was facing a felony burglary charge, and he ended up with a 5-year sentence because he didn't have a lawyer to defend him. So here, a unanimous decision by the Supreme Court said that our Sixth Amendment right to counsel ensures that if we are charged with a felony, even at the state level, we will be provided with a lawyer if we need one, which is what a public defender is. All right, then we get to this issue of the right to privacy in regards to a woman's right to decide if she wants to have an abortion or not. There were several cases before Roe versus Wade in which the court established the right to privacy for a woman when it came to birth control. Here they're applying it to the decision to have an abortion. So 7-2 decision, a woman's right to an abortion fell within the right to privacy. And basically during the first 3 months of pregnancy, a woman has an absolute right to decide for herself, that's the right to privacy part, whether or not she wants to have that go through with that pregnancy. After 3 months, states can go into a little more restrictive measures. So further into the pregnancy, states are going to have more and more laws and regulations about getting an abortion at that point. And of course, there were some dissenters. The 2 dissenters completely rejected the idea that the Constitution would protect abortion rights at all, and that should be completely left up to the states to decide whether abortion should be legal or not. All right, Brown versus Board of Education, very famous case. Whether or not segregated schools violated the Equal Protection Clause of the 14th Amendment. If you recall, there was a case prior to this that established the separate but equal doctrine. That was Plessy versus Ferguson in the 1800s. Here, they basically said when it came to schools, you could not have separate and equal facilities in regards to education, because segregation of public education based on race instilled a sense of inferiority that had a huge detriment on the education of African American children. So you can't have separate but equal schools. So it ended segregation of schools. And then finally here, the Citizens United case. This is one we have not talked about. This will be talked about more in the upcoming units 4 and 5, dealing with politics and elections. So here, Congress wanted to pass a law that restricted how much money corporations could use in terms of creating advertisements to support certain political parties or candidates. Previously, there had been laws upheld that said you could not give money directly to candidates, or you could only give so much money to a candidate if you were a corporation or even an individual, because they were worried about the influence that had on that potential lawmaker. So some people would argue it's almost a form of bribery. If I'm running for election and you give me $1 million, then of course I'm going to owe you some sort of favor. Here, the law that was up for debate was the McCain-Feingold Act, which was restricting independent election spending. That means if I was McDonald's and I wanted to spend millions of dollars supporting a certain presidential candidate, should there be any restrictions on how much of my own money, even though I'm a business, can I put into supporting a party or a candidate? The majority here back in 2010, 5-4 majority, looked at businesses just like they looked at people. The idea that if a person can contribute as much money or spend as much money as they want supporting candidates, as long as you're not directly giving a candidate money, that is considered political speech, and it's protected under the First Amendment. So they looked at corporations just like they looked at people. So a lot of times you'll hear that in the news, that corporations are sometimes treated as a person, whether it's Walmart or McDonald's or General Motors. That company has certain legal rights just like a person would. And in this case, the majority said they have the right to political speech. McDonald's wants to support President Trump or whoever the Democrat's going to be. They have that right to spend as much money as they want, creating their own advertisements, and that shouldn't be limited. The dissenters, of course, argued that the First Amendment should not apply to corporations, only people. So they didn't see corporations as people, and that Congress had the authority to limit the amount of money a corporation would have in terms of influencing election with millions and millions of dollars. So they were the dissenters wanted to protect the integrity of elections, but the majority, of course, won. So millions and millions of dollars are spent creating ads for and against political candidates. So those are the required cases. Those are the ones that could possibly show up on the test. So make sure you know those required cases. There are other cases I've included here. I'm just going to kind of go through them quickly by name. You can always pause the video and look at those, but they are important. They're not required, so if you don't want to look at them, that's up to you. But I think if you know them, it'll give you a better understanding of some of the issues, and some of them you're going to recognize. Gibbons versus Ogden, the Dred Scott case, Plessy versus Ferguson, which I mentioned before, Korematsu, Gitlow versus New York. This was the first time the Supreme Court selectively incorporated the Bill of Rights to apply to the states. In this case, it was the First Amendment. There's the Griswold versus Connecticut case that dealt with birth control. Mapp versus Ohio, which dealt with the Fourth Amendment's protections against illegal searches. Miranda versus Arizona, the Miranda warnings you see there. Fifth Amendment's rights against or protections against self-incrimination. The Lemon case, this created the Lemon Rule. You know, how does the court look at laws where religious laws where the government and religion are too connected? So it's called the Lemon test. Laws cannot have a religious purpose, they cannot encourage or discourage religion, and they cannot entangle government up in religion. It's called the Lemon test. So that's how the courts look at laws that may or may not impact religion. The Bach case, remember the Bach case deals with affirmative action, which is one of the new issues you're looking at in this unit on civil rights and civil liberties. So make sure you know the Bach case. Buckley versus Valeo, this is one of those cases that dealt with spending money on elections and how much you could contribute to candidates. So this case allowed the restriction of money when it came to directly giving candidates money. And of course, candidates themselves could spend as much of their own money as they wanted to. And then finally, a case that gets talked about sometimes, Bush versus Gore. a very contested election in 2000 between George Bush and Al Gore. In Florida, there was some complications with the voting system, and what happened was there was just a recount, and they kept recounting votes. They were throwing out votes that they thought were invalid, and eventually Bush challenged this recount, because the recount, what it was doing, they were throwing out votes, and there was the potential that Bush was going to lose Florida if they kept throwing out enough votes. And if he lost Florida, then Al Gore would have become president. So he challenged this process of recounting and throwing out votes in court, and he won. So a lot of people look at this case as they claim that this case helped Bush become president. I'll leave that up for you to decide, but they use the idea of equal protection, saying that there was no standard set for recounting, so the idea that some ballots were being thrown out, that was violating people's voting rights under the Equal Protection Clause. So those are cases. Like I said, some of the cases are required, and then these last several cases are just interesting to know about. But that'll be it for this discussion of cases. So if you haven't finished your court case chart, make sure you get that to me as soon as you can, because starting on Monday, we'll be diving into the world of politics, and we'll be doing some interesting things with looking at your own personal beliefs and what you feel about different issues. So that's where we're heading next week. And make sure you go online, AP Classroom, do your tests, do your progress checks, because remember, we still have an exam to prepare for. And I'm thinking that because it's going to be a shorter exam, that's to your benefit. So the more you prepare, the more likely you are to get that college credit. All right, you guys take care. I'll see you next time.